Welcome to The Silent Verdict.
With Clara Monroe and Elias Gray.
You know, sometimes the most ordinary day, just a simple afternoon in the park, can go horribly wrong. And one decision about where to hang a hammock, well, it ended up sparking a tragic, incredibly complex, and million-dollar legal battle.
Think about it, a hammock, right? A symbol of pure relaxation. A lamppost, just a normal piece of city infrastructure you walk by every day. And then a disaster that ties them together forever and raises some really tough questions about who's responsible when things fall apart.
So, how on earth does a day in the park turn into an absolute nightmare? Well, it all goes back to one single moment.
Okay, so picture this. It's June of 2022 in Irving Park in Portland. An adult babysitter and a 9-year-old boy she's looking after decide to kick back and relax. They find a spot, string up a hammock, tying one end to a sturdy tree and the other to a big old concrete lamppost. But that lamppost just wasn't designed for that kind of stress. It snapped right at the base and came crashing down on top of them.
The physical damage was, as you can imagine, horrific and immediate. But the legal mess that followed? That was way more complicated, and it all boiled down to one single million-dollar question.
So in any lawsuit like this, you've really got two key pieces: damages and liability. Damages, that's the harm, the injuries. Liability, that's who's legally at fault. And here's the thing, you can have the worst damages imaginable, but if you can't prove someone else was legally on the hook for it, you don't have a case. And that is the absolute core of this whole fight. And on one side, I mean, the damages were just catastrophic. Nobody could argue with that. The little boy had a fractured skull, jaw, and leg. He even needed open heart surgery. The babysitter suffered a crushed pelvis. Their medical bills just shot past $186,000. But on the other side of all that pain is the big question: who pays? Was this just a freak accident? Did they misuse the equipment? Or was somebody, somewhere, negligent?
With that much money and suffering on the line, the lawsuits started flying, and it created this tangled web of finger-pointing. Let's break down how everybody tried to shift the blame. The argument from the boy's family and the babysitter was pretty direct. They said the city of Portland was negligent. Their whole case was that the city knew, or at least it should have known, that these old lampposts were a potential danger, and it did nothing to warn people.
So this is where it gets really interesting. The plaintiffs, the injured parties, sue both the city and the company that made the hammock. The city of Portland fired back saying, hey, we're protected by recreational immunity laws. And besides, the lamppost was being misused. Then you have the hammock company. They said, look, our instructions are sewn right onto the hammock. It says attached to healthy trees only. But then they made a really aggressive move. They turned around and sued the babysitter directly, blaming her for the whole thing. For a while, the case was just this messy stalemate of blame going in every direction. But then a piece of information came out that completely changed the game. It all centered on what the city knew, and crucially, when they knew it.
And really, this became the question that mattered most. Was this accident a truly unforeseeable one-in-a-million event, like the city was suggesting? Or was the city aware that it was sitting on, essentially, a ticking time bomb?
290. That's the number. That's the number that changed everything. It turns out that 9 months after this horrible incident, the city did a safety assessment. And that assessment identified 290 lampposts, just like the one that fell, as being a potential hazard. And they removed them. All of a sudden, the plaintiffs claimed that the city knew about the danger. Well, it wasn't just a theory anymore. It looked like it was backed up by the city's very own actions.
Faced with that number, 290. The idea of going in front of a jury suddenly seemed like a really bad idea for the city. So the case never got there. Instead, everyone decided to resolve this out of court.
The city of Portland agreed to pay out a total of $942,600. The boy received the lion's share, about $782,000, and the babysitter got $160,000. Now that number isn't random. It's actually the absolute maximum amount the city could possibly pay under Oregon's state tort claim limit.
But what about the hammock maker?
the company that actually sued the babysitter. They settled too. But since they're a private company, the details of their settlement are completely confidential. We have no idea what they paid or to whom. It just adds another layer of mystery to the whole thing. So you might be asking yourself, why would the city agree to pay out the maximum amount the law allows? Why not roll the dice with the jury and try to win? Well, the answer comes down to the cold, hard logic of managing legal risk. For a defendant like a city, going to trial is a huge gamble. Just imagine a jury seeing the photos of those injuries, hearing the story of that little boy's recovery. That kind of emotion can just wash away legal arguments. Plus, juries often see a city as having deep pockets, so they might award a massive amount of money. But the real killer? The city's lawyers knew that number. $290 would be absolutely devastating in a courtroom. A settlement, even a big one, is a sure thing. It's a predictable cost. A jury is a complete unknown. And this is the core legal principle a defendant would hang their hat on. In a perfect world, the law says that just because someone was hurt badly doesn't mean you owe them money. You only owe them if you were negligent. But the city's fear, and it was a very real fear, was that a jury's sympathy for a horribly injured child would be too powerful to overcome. And that was a risk they just weren't willing to take. Ultimately, this whole case leaves us with a really tough, unsettling question. We all expect our public parks to be safe, right? But we also have a personal responsibility to use them in a reasonable way. This terrible story sits right in that gray area, forcing us to ask, where exactly do we draw the line between our own judgment and a city's duty to protect us from every conceivable danger, even the ones we might accidentally create for ourselves?